DEI, say goodbye. A federal court of appeals ruling in favor of a conservative group that argued a grant program strictly for Black female business owners is discriminatory.
Today, that court decision is being used as the basis for the Equal Protection Project to issue a cease and desist against nonprofit the Rhode Island Foundation for awarding race-based scholarships and grants like one of their student loan forgiveness programs that only forgives the loans of non-white teachers.
Joining us now, the founder of the Equal Protection Project, William Jacobson. William, good to see you. This decision by this U.S. Court of Appeals, it did not, against this grant program for Black female entrepreneurs, it did not involve government money and just private money? Because that seems, even to Sean and I, really kind of pushing the envelope here.
Well, it's a historic decision, and it's going to shake up the $500 billion a year philanthropy industry. And it was brought under the Civil Rights Act of 1866, 42 U.S.C. Section 1981, which says that you cannot discriminate. Private entities cannot discriminate in contracting. It was a post-Civil War statute, post-Civil War Civil Rights Act, meant to equalize contracting rights, and it has been held by the U.S. Supreme Court to protect not only freed Black slaves and not only Blacks, but also whites. So while it may be shocking to people, it's really kind of just applying the law to this, and it will shake things up, because there are many entities around this country that we see at the Equal Protection Project, such as the Rhode Island Foundation in Providence, where I'm located now, which have numerous scholarships and grant programs which are private money by private foundations, which limit themselves to certain applicants. Sometimes it's Black applicants, sometimes they use the term people of color. There is widespread and rampant private grant discrimination going on in this country. And the Fearless Fund case, I think, is going to shake things up, because it's really just applying the law. And we want the Rhode Island Foundation to stop doing what they're doing and have race-neutral grant funding and race-neutral scholarships.
So how does it shake it up? Is that what the future is? Listen, we're not going to use race as a criteria for getting grant dollars or scholarship money.
That's right. There's nothing to prevent philanthropy from trying to improve minority communities, from trying to do what is loosely called diversity, equity, and inclusion, but they can't do it on a racially discriminatory basis. You cannot have a grant program that says whites cannot apply. And that's what a lot of these foundations are doing. At Equal Protection Project, we've brought dozens of claims against universities and other educational institutions that do this. But what is so important here, as you pointed out, is this is all private money. You cannot do this. And I think the philanthropy industry needs to wake up, because this could lead to lawsuits not just against the philanthropies, but against donors who insist on these conditions. There are a lot of these grant programs that are created by donors, and the donors insist on these racially discriminatory terms, and they are now at risk.
But, William, really quickly, but in this case that we're talking about, this Court of Appeals decision against the Fearless Fund, the Fearless Fund argued that these were charitable donations and not contracts. And so does this decision then go to an even higher court? Does it go to SCOTUS?
Well, I hope the Supreme Court takes it, frankly, because I think we need to resolve this nationally once and for all. But the Court of Appeals was very careful in saying this grant-making process where you have to apply, there are rules, you agree to abide by those rules. They issue the equivalent of a contract that you have to sign for the grant, that this is contracting, this is not mere donation. Nothing in this opinion prevents you from donating to whoever you want. But if you're going to run a contractual grant program, you have to do it in the law.
William Jacobson. Interesting. Yeah. Thanks for coming
really
and sharing the case with us. We appreciate it. Thanks for being on The Bottom Line.
Thank you so much.